All right, so that was when Jason Van Dyke took the stand in his own trial, and today we are covering the trial of his fellow officers who are accused of covering up what really happened during the Laquan McDonald shooting. Let's break down all aspects of this case right now with our very special guest, Law and Crime trial analyst, Jonna Spilbor. Jonna, great to see you, and welcome to our new area.
I know, I'm so excited.
So let's just start with Van Dyke right now. I don't know if you and I have had the opportunity to discuss this, but were you surprised by the verdict? 1 count, second-degree murder, 16 counts of aggravated assault. What do you think?
I still am surprised by the verdict. I actually think, and we covered this, I was with you for part of this case, and I think I went on the air and predicted this was not going to be a murder conviction, and lo and behold, I was wrong. Happens rarely, but it happened.
What do you think happened? Because basically the jury listened to him testify and didn't believe that side of the story.
You know, but when you watch him testify, he does come across as genuine. He does come across as believable. And look, for me, it was this. We weren't dealing with a defendant who was just John Q. Public, right? We're dealing with a police officer who I think the victim in this case had a history with this particular police department. There was a weapon in his hand. Murder to me, murder to everybody, requires an intent. And here I think the officer truly thought that he was justified in protecting the community and protecting himself and fellow officers. And therein lies the rub, Jesse.
Then why did he shoot him so many times, including when he was on the ground?
He explained that, though. I know he shot him 16 times, but it wasn't as if he consciously, you put your finger on that trigger and 16 bullets are coming out. Basically, it's almost like an unconscious thing when you're a police officer who is trained to shoot. And I believe he testified in situations like this, he thought he was following protocol.
When you look at this video, though, this dash cam video, does this appear to you to look like a situation where you need to use deadly force at that moment? I mean, you see him walking away from the officers. Now, again, the question is, was he going towards the public in an area that one of the arguments was, well, he's going towards the public. He could be a danger to someone in a nearby location. But at that moment, why did he open fire at that exact moment?
You just honed in on probably the key issue for the jury and why they came back with the verdict that they did. When you just look at that video, it doesn't appear that anybody is in imminent danger, even though the victim in this case is carrying a weapon. But he's far enough away where it doesn't appear necessary. And even though certain witnesses tried to explain the situation and explain the video a little bit better, like this was our perspective that you can't see, ladies and gentlemen of the jury, that portion of the testimony had to have fallen flat or we wouldn't be looking at a murder conviction here.
Okay, well, that is Jason Van Dyke, and you talked about other people. When we come back from our break, we're going to talk about other people, the 3 officers who are currently on trial for allegedly trying to cover up this shooting. We'll talk more about it right after this. All right, welcome back, everybody. At around 12 p.m. Eastern Standard Time, we expect to be live in day 2 of the cop cover-up trial in the Laquan McDonald shooting. Now, if anybody doesn't have any idea about this case or is unsure of what happened yesterday in court, here's a report by our very own Rachel Stockman about this case. Take a look.
Chicago police officers are facing obstruction of justice and conspiracy charges for reportedly lying about the shooting death of a black teenager. Prosecutors say former Detective David March, Officer Thomas Gaffney, and former officer Joseph Walsh intentionally attempted to conceal the facts of the killing of 17-year-old Laquan McDonald. Laquan was shot and killed by the trio's colleague, Jason Van Dyke. Van Dyke was indicted in 2015 for shooting the victim 16 times. He took the stand in his trial and claimed that he shot because the victim, who was holding a knife, was coming towards him.
What was Laquan McDonald doing?
Advancing on me.
And did you say anything to Laquan McDonald?
I was yelling at him, drop the knife. I yelled it, I don't know how many times, but that's all I yelled.
And did he keep advancing toward you?
He never stopped. He waved the knife from his lower right side upwards, across his body, towards my left shoulder.
And when he did that, what did you do, officer?
I shot him.
But some state witnesses had a different story.
Before you see him fall, did you see him raise his arm as if he was attempting to stab anyone?
No.
Did you see him attack anyone?
No,
Did you see him walk, run, or charge at any officers?
no,
Van Dyke was found guilty in October of second-degree murder and 1 count of aggravated battery for each of the 16 shots. He was acquitted of official misconduct. Court documents accuse March, Walsh, and Gaffney of a medley of crimes, including mischaracterizing video recordings, creating false police reports, and failing to report false information in order to protect themselves and Van Dyke. The indictment claims that Walsh, Gaffney, and another unknown person reported they were victims of McDonald, and another unnamed person was injured by the offender. That claim was allegedly reviewed and submitted by Detective March. It also says a reported false claim attributed to Officer Walsh stated that the victim attempted to get back up after being shot while still holding the knife. Claims that the video evidence of the shooting does not support. All of the officers entered a not guilty plea to the charges. For Law and Crime, I'm Rachel Stockman.
All right, great reporting there, Rachel. Let's talk a little bit more about this, Jonna. So the idea, let's just talk from a legal perspective, okay?
All right.
How do you prove, if you're the prosecution, a conspiracy here as opposed to just bad reporting, bad police work? No, this is a conspiracy. They deliberately acted to conceal information. How do they do that?
I think it's going to be a little bit difficult, and perhaps, I mean, maybe in this case, the prosecution is going to rely, just like they did in the Van Dyke case, on that video. When you look at the video and then you read the reports, right? They don't seem to, they're like 2 totally different happenings. Like, what event were you looking at? Because the video does not support what's in the actual reports. Now, you know, we're not cops, Jesse. I don't know what the protocol is. Is this common? Did they follow the protocol when they were creating the reports? I have an issue with, like, let's suppose you were up for your annual review. Nobody's going to hand you a piece of paper and say, Jesse, how do you think you're doing, right? Because this is what these cops are policing each other, and nobody wants to get in trouble. And perhaps this is routinely how they conduct these investigations on themselves. That's what I want to know. And perhaps, and if there were a jury, the jury might want to know that too.
Oh, we're going to get into all this about the reports and how were they reviewed, how were they submitted. We'll get into all this, but let's start right now from the prosecution's opening statement from yesterday in case you missed it. And this is a great explanation of where the state plans to go. Take a look. All right, that's the prosecution elaborating on that conspiracy charge in the opening statement. But let's take a step back, John, and let's not forget that who she's speaking to is not a jury, but a judge. This is a bench trial. How does that make that a little bit different moving forward?
So this is strange to me. Since the prosecution knows that they were successful in front of a jury getting a murder conviction plus against the Officer Van Dyke, I am surprised that they, well, I guess it really is the defense who would waive jury and just bring a case in front of a judge. I have never done that in the course of my career, Jesse, unless I have had, I'll call a wink and a nod from a judge that he or she was inclined to rule in my favor, and I didn't want to take a risk of having 12 strangers make that decision. It's not foolproof. That doesn't fly. Of course, a judge isn't supposed to tell you how they're going to rule, but before you get to any trial, bench or jury, there is a lot that happens in front of that judge. So you get a sense of which way the judge is leaning in your case or what they're going to want to see or hear in order to rule in your favor.
But is that because, and look, I'm not discounting anything about being on a jury. It's a very hard task, and yes, they have to review the law just like anybody else, but let's not remember, they are not trained in the laws the same way a judge is, correct? So the idea is, do you want to present those cases? Do you want a judge to decide those cases that's more legal specific,
more
as a
technical.
more you know what I'm saying here? Like, what is the advantage of saying I want one judge to decide this as opposed to 12 jurors? And let's not forget, this is a very emotionally charged case, and all of Chicago was watching the Jason Van Dyke trial.
It does make sense usually when you have a purely technical, legally technical defense to put it in front of a judge who's going to be able to parse out those issues. And perhaps, I mean, look, maybe the defense team in this case is looking at the Van Dyke trial and saying, well, we think the jury got that wrong. Why should we entrust this case to another jury who also may get it wrong? That's probably what went into the thinking when they decided to waive a jury in this case. And it doesn't mean they're going to be found not guilty. Anything could happen here, but if they're going to really parse out the issues technically, then perhaps a judge is the better person to do that.
Is this a case where you're going to see a verdict across the board for all three, guilty, not guilty, guilty? Because what it seems like to me is there's an overlap with the three of them. It's kind of hard to separate.
Right.
Do you expect a verdict down the line? They're all found guilty of everything? They're all found not guilty of everything? Or is it going to be parsed out? I know it's hard to predict.
If you're mounting a technical defense, it could go either way. It's a little bit odd that they're being tried together, even though I know they acted in concert. A lot of times it's not beneficial to let's say there's one defendant who's like, I had nothing to do with this, but you're sitting next to two other defendants who likely did. Now you're almost guilty by association, which could be another reason for the bench trial and not a jury trial.
I'm glad you mentioned that, because when we come back from our break, we're going to show you the defense's opening statements for each one of those defendants, similarities and differences in the arguments. We'll be right back. Okay, so that's defense counsel for David March really providing an impassioned plea to this judge about why there's really no conspiracy here. And one of the points that he's making, Jonna, is that, well, look, my client had access to that dash cam footage. If he really wanted to cover it up, he could have deleted it. He could have done something to it. He preserved it for trial. But I'm curious your perspective on seeing some of that opening statement.
A couple things. Number one, the tone. Jesse, if you played that and didn't tell me what it was, I wouldn't say that's an opening statement. I'd say perhaps it's a closing argument. I don't understand why this attorney's coming out of the gate like, very, you call it impassioned. I think he's being a little overbearing. But here's the thing I don't like about his argument. Like, I get, all right, so he didn't destroy evidence. And if he were going to be covering up this case, why didn't he destroy the biggest piece of evidence there? Well, destroying evidence is a crime. And so to argue that, hey, my client, he's accused of committing these 3 crimes, but he didn't commit this 4th one, doesn't really fly with me.
That's a pretty good point.
Yeah, I mean, I get it, but I don't think it holds a lot of water.
Well, I want you to, I want to see a reaction now to the different defense counsel. Now, this is defense counsel for David Walsh in his opening statement. Let's see how he did. 3 different defense openings, and now let's analyze all of them. John, I'm back with you. You saw it now for the 3 different styles. I'm curious your perspective on seeing the opening statements for the defense counsel for Officer Joseph Walsh and Thomas Gaffney.
Well, this last defense attorney, I think, did an excellent job. Not only in his demeanor, where he didn't have to scream at the judge, but he raised an interesting point. He's basically saying the documents that you're accusing, that the prosecution is accusing of being false, wasn't false at all. And he's describing what was in the report in terms of the assault. And just so that everybody knows, I think sometimes people think an assault is an actual physical touching, an unwanted touching, but it's not. And in Illinois, it's simply an assault is something that places a person in reasonable apprehension of physical harm. So when you're a police officer on a scene and there's a person with a deadly weapon, and as they described in the previous trial, he had like a blank stare on his face, he had previous police contacts. If he makes a move with that knife in his hand, does that constitute an assault? And if so, then perhaps this last defense attorney is correct in saying there was nothing false in this report.
In other words, one of the defense attorneys, I think it was for Thomas Gaffney, said this is not an instance of a cover-up. But what this is an instance of is the state just disagrees with their reports. Is there any water to that argument?
Well, listen, the standard is still the standard. Whether you have a jury or a judge, it's proof beyond a reasonable doubt. And if you create a question as a defense attorney in that judge's mind as to whether this is just a misunderstanding as opposed to an actively, purposefully falsified document, you've created reasonable doubt.
So what did okay, so now they have these 3 different styles. The idea of having 3 different attorneys, different styles, different arguments, does that complicate the trial?
Well, it can, because we now know if you have 3 different attorneys, the defense isn't, you know, the 3 Musketeers defense, like one for all and all for one. They each have their own defenses to the same crime. So the judge is really going to have to parse out which evidence to put with which defendant. And that could make it a little bit messy or complicated, I should say, for the judge in rendering a verdict at the end of the day.
But we're going to get into those reports, right? And is the case made on those reports? In other words, is it all about what they wrote? Is it really, I mean, we're going to talk a little bit about comments that they may or may not have made, which definitely doesn't help their case. But the idea of those reports, have you ever seen a case quite like this before, where it's all based upon what their report stated?
I haven't seen a case quite like this, but I think you're touching on something that's crucial. And not in terms of whether they filed a false report, but how is the prosecution going to prove the conspiracy element, especially when it seems like this person was filling out that portion of the report, this person was filling out. Where does the conspiracy come in?
Okay, let's talk about that. One of the things that we're going to analyze a little bit later is similarities in language and words and terms in the reports. What do you think?
Could be standard operating lingo. Just if a cop's writing out a traffic ticket, they don't reinvent the wheel. They don't get colorful. I mean, there are certain words and phrases that we use in our business, that police officers use in their business, that are just common. And maybe that'll be part of the argument once those reports come into evidence, if that's what they're using, the similar language to prove the conspiracy.
Jonna, have you ever said you're a pretty good defense attorney?
You can tell me more.
Well, Jonna's making some good arguments here, and we actually have a lot more to analyze before we go live in that courtroom at around 12 p.m. Eastern Standard Time, because yesterday was a really big day in court. We had all these opening statements, and we saw the testimony of two key witnesses that we're going to break down. So let's take a quick break. When we come back, we have more to analyze and a lot more to talk about here on Law and Crime. We'll be right back. Okay, let's talk a little bit about this. I'm back here with Law and Crime trial analyst Jonna Spilbor. Dora Fontaine came up yesterday in court because the defense attorney was saying that she changed her story in order to save her job, that the first thing her report says was that Van Dyke was injured in the confrontation with McDonald, and that according to Mr. McKay, who's the defense attorney for David March, the inspector general wanted her fired too. She did change her story to save her, you know what. What do you think about that?
Well, she's a controversial witness, right? She's the one that the other police officers are referring to as a rat. And it's important, the point that these defense attorneys are trying to make is her testimony credible? Because again, just because we don't have a jury here deciding whether or not to believe a witness, the judge is tasked with the same thing. So she needs to decide whether this person's testimony should be believed over everybody else's. And that's a good question.
Well, then what's going on here? Who do you believe? What was the goal of the police department? To justify the shooting, not justify the shooting, not take the facts? I mean, what's going on?
But look, I mean, let's parse her out for a minute, because at some point the prosecution had to look at the sea of potential defendants and decide who among them was going to promote their theory of the case. They pluck her out. So now she's got to basically, she is saving herself with this testimony, Jesse, because she's not sitting at the defense table. So perhaps there is some weight to the argument that, wait a minute, this particular key witness wasn't being truthful then, isn't being truthful now. Let's discount all of her testimony.
All right, let's fast forward to now, this trial, when the prosecution mentioned Dora Fontaine in their opening statement. Take a look. So, Jonna, I'm a little scared. I don't know.
Me too.
I was watching that. I was like, oh, okay. Taking that aback, though, let's focus on Dora Fontaine. We're getting two different perspectives on this officer. What do you make of it?
Right. You know, Jesse, let's look at this in a more common light. You know, when you have a group of defendants that are not police officers, let's say they're drug dealers or, you know, a common criminal, and the prosecution peels one of them off so that they can better get a conviction, hopefully, against the others involved in the crime. When that person that the prosecution peels off takes the stand and, quote, turns state witness, there's always going to be an issue of credibility as to why the motive behind that person testifying. Is it to save their own behind, or is it for a greater good? And just because this particular witness wears a uniform and is a police officer, the analogy is the same. And the trier of fact, in this case the judge, is going to have to determine, was this person, you know, rightfully indignant because words were taken out of context or attributed to her that didn't come out of her mouth? Or is this person necessary for the prosecution to prove a case and therefore motivated to bend the truth? And that's going to be a critical question for this judge.
But did you get the sense that what he's arguing is, well, how can you blame my client for writing this report when you have an inconsistent witness? Is that what you were getting to?
That's probably one area that it's hard. I'm so distracted by his angst and anger that it's hard to, but you're right.
I feel like he's yelling at me a little bit.
Right? That's what we feel like. But he's trying to put a little bit of a cocoon around his client, which makes sense from a defense perspective. So that's probably the avenue that he's taking here.
All right. Well, explosive day in the courtroom from yesterday, and we have a lot more to cover. Let's take a quick break. We'll be right back. Jason Van Dyke's testimony, this official report, Jonna, this isn't true.
What's not true?
This is not how this went down. I mean, really, this is see, here's the thing. Here on Law and Crime, we can play the testimony from Van Dyke in here, and we can put it all together for a nice story. That's not the same situation in this courtroom.
Right.
What's going on here?
So we have a fundamental, the defense camp and the prosecution, and even Officer Van Dyke, I think all have a fundamental misunderstanding about whether or not any officers were assaulted / attacked. Because clearly, this victim did not attack anybody, at least not on the dash cam video that we saw. There's no attack going on.
He didn't advance or lunge or anything like that.
But could there, from a different perspective, and that's the key word that Officer Van Dyke used, from his perspective, which is different from the dash cam perspective, did it happen that this victim actually did commit an assault? He did not convince a jury of that, or he wouldn't be sitting in jail right now on a murder charge. But also, it is the critical component, Jesse, I think, of both cases, whether or not a trier of fact is going to believe that the victim in this case, Mr. McDonald, actually did commit an assault.
Was it appropriate for these officers in their reports to list the victims of this as Van Dyke, Gaffney, McGilligot, and Walsh? Was it appropriate for David March in his report to say criminal attacked officer, then that officer killed criminal?
If these reports are the product of certain officers at the scene stating to an investigating officer who then writes it down, and we don't learn whether or not the reporting officer said attack versus assault, then it's going to be hard to determine whether these reports are intentionally false. I'm playing devil's advocate defense attorney right now. And perhaps that is going to be, again, they just need to raise reasonable doubt, Jesse. They don't have to prove, the defense camp doesn't have to prove a darn thing.
Like you said, these are very minute legal issues, and we can't forget that the judge, one person, will decide these issues. Let's take a quick break. We'll be right back. All right, so that's the arraignment of George Wagner IV. We're going to jump back into that courtroom in a second. This is a really crazy case where it's a different family. We got George Wagner IV, Edward Jake Wagner, his brother, Angela Wagner, and George Billy Wagner III, the parents, who are also charged in connection with the shooting death of this other family, the Roden family. What's supposed to happen here in an arraignment?
So these are really just standard operating procedures. Typically an arraignment kicks off a criminal case where the defendant or defendants are provided with the nature of the charges against them. They have to basically confirm that they understand the nature of the charges against them, and then essentially the defense attorney preserves their constitutional rights and they enter a plea. I think 100% of the time in my career, Jesse, that plea at this stage of a criminal case is a not guilty plea because you haven't done anything yet. You haven't conducted discovery. You haven't gotten into the meat and potatoes of the case.
That's exactly right. We're going to jump back into that arraignment. Remember, he faces an aggravated murder charges and could carry the possibility of the death penalty. Let's go live back into that arraignment. Okay, let's break down what's happening right now. Jonna, one of the things that we should note is this is a family who is being charged with the killing of another family, and we know that Edward Jake Wagner pled not guilty in court. The mother and father of these two boys are going to appear in court, maybe pleading not guilty. We believe George Wagner will plead not guilty. So is this a situation where you might have family members turning on other family members because they're all facing aggravated murder charges?
Absolutely. It's a little bit unusual when you have a mass murder like this, and obviously they have their group of defendants, but the killing occurred in 2016, so
right.
Obviously there must have been a pretty substantial investigation here. And what we're looking at on the screen is just, I don't want to say it's unusual, because in a case this serious, obviously the judge is going to want to make sure that he reads all the nature of the charges to the defendants. But in a typical case, when you're not dealing with a capital murder case, it's quite common to waive this portion of the program, meaning waive a reading, so that you're actually in and out, you enter your not guilty plea, and if bail is not set or you're free on your own recognizance, you walk out the same door you walked in. And if not, and I'm going to assume these people are not going to be set free, then you're off to jail for the duration.
Are you surprised that they weren't tried together? Or that by same counsel, or is that would that have been a conflict?
No, I think I'm not surprised that this is. I don't think this should be a group defense. It's rare that you want a group defense anytime, Jesse. But in a case this serious, obviously, when you have so many players, there might be some people who maybe were bystanders, had nothing to do with it, and there might be some others who were actively involved in the murders or conspiring to murder or what have you. So it's not uncommon at all to have them separate for the entirety of the case.
Would you be surprised if they're all brought to separate trials, and let's say they're all convicted, you might have a situation where some might be sentenced to death and others not?
That could happen. Yeah, that could happen, depending on the level of culpability. And remember, when you have a death penalty case, the penalty phase, it can be very impactful, right? You can have the most heinous crime in the world committed, but either the defendant or somebody on behalf of the defendant can say something that really sways a jury to spare that person's life. So who knows?
Yeah, what a bizarre set of details this case is. Really sad. Let's take a quick break. When we come back, we'll have obviously a lot more to talk about. We'll be right back here on Law&Crime. Again, this is the arraignment of George Wagner IV. It should be noted that 7 adults and a teenage boy were found shot in the head at 4 separate homes back in April of 2016. Jonna, this is remember, he's charged with aggravated murder as well as other counts. This sounds as premeditated as you get. Sounds like a law school example.
Yeah, and that's what is in the allegations, too, that this was all prior and planned. This is pretty gruesome.
Well, this killing terrified local residents. I mean, this was something that was unsolved for a while, and clearly so.
Yeah, and I would like to find out what the motive is. I mean, assuming that they have the right defendants here. Like, was this a drug thing, a custody thing, a Hatfield and McCoy thing? This was really when you go from house to house, killing basically an entire family of you can't get around the premeditation that is alleged in this case.
I wonder, is there any way to articulate and say, hey, listen, the first killing was maybe we weren't sure if we were going to do it, and then we got there and did it, or maybe, and then after that they're like, let's just go and get rid of the others. I'm speculating. I really don't have a lot of information about this, but I'm curious, trying to think about possible avenues for the defense attorneys here.
You definitely have time to reflect after you kill somebody in one house. Get in your car, presumably, and go kill people in 3 more houses. There's definitely time for reflection there.
This was a result now of a massive investigation. It's all coming to a head right now. Let's jump back live into that arraignment right now.
2923.
Some serious charges right there. Wow, the George Wagner IV arraignment. We're jumping out of that for a second. Jonna, I know our time together is coming to an end, but I just want to thank you for coming on and breaking down all the cases today.
Always happy to be here, Jesse. And glad you're okay.
Yeah, I'm okay. I'm okay. No worries. Jonna, thank you so much.
Thanks for having me.
We're going to take a quick break. When we come back, we'll probably be back live in that courtroom. And joining us up next will be Gene Rossi. So stay tuned here on Law&Crime.